Okay, good morning, everybody. Welcome to this webinar, which is hosted jointly by Pinsent Masons and Keating Chambers. Delighted to have you here with us today. We've got a very, very strong audience from across the African continent, which is great, and we've got a very, very interesting topic to discuss. And that topic is to do with virtual courts and hearings. My name is Richard Laudy, and I have the pleasure of running the Pinsent Masons Africa business. I'm joined by three panelists from Keating Chambers and from Pinsent Masons. The last 18 months or so have changed the world, as we know. Not only have it changed the world, it's also changed the way in which lawyers have had to think and work. 18 months or 2 years ago, virtual hearings were virtually unheard of, whereas nowadays they seem to be very much the norm. So it seems that now, as the world slowly starts to emerge from the pandemic, it seems that now is a sensible time to be reviewing the lessons that we have learned, and to consider in particular what that might mean for the future. Is what we've seen in terms of virtual courts and hearings, is that here to stay? Are those hearings always fair? Do they promote access to justice? Do they create opportunities, perhaps, for the development of new regional centres? Do they mean that the hold that some of the international dispute resolution centres have traditionally held on international dispute resolution will be released? And that perennial question, which often gets asked, which is, why can it not be that more disputes that happen on the continent of Africa can be resolved in Africa? Might it be that question is finally going to be answered? To help us discuss these issues, we have three very knowledgeable colleagues, and those colleagues are able to bring us the perspective of an international judge and arbitrator, an attorney who practices on the continent of Africa, and an advocate who practices on the continent of Africa. And in addition, and perhaps most importantly, in addition to our three panelists, we have, of course, all of you, because we very much want this to be an interactive session, and there will be the ability for you to pose questions to us through me via the chat box. So with that, I'm going to introduce our first panelist, who will set the tone by giving us some introductory marks, and after that we'll move on to the other two panelists. Our first panelist is Sir Vivian Ramsey, and Vivian is a very, very old friend of mine. We go back a very, very long time indeed, to when I started out in construction law, which was many, many, many years ago now. Vivian has worked as an international advocate, as a High Court judge in the UK, more recently as a judge in the International Commercial Court of Singapore. He has been the editor of Keating on Construction Contracts and a former head of chambers at Keating Chambers. And he currently sits and works as an international arbitrator and mediator. So he's very, very well placed to start our webinar today by giving us an international flavour and perspective to this important topic. Vivian, I remember going back to some of the early days of our relationship when you were, if I can put it, an early adopter of technology in courts and in arbitrations. And I can remember back then you saw opportunities for the UK High Court to adopt technology more. And I remember when you moved to Singapore, I remember you talking to me about some of the uses of technology that you were seeing the Singaporeans adopt. My question to you is whether the events over the last 18 months, 2 years have in any way altered or affected the views that you formed in those early days, and really whether you still maintain that technology opens up the opportunities that you once thought existed.
Yes, well, good morning, everybody, and thank you, Richard. We're old friends, but I don't think too old, not to call ourselves young still. The question you pose is obviously an interesting one, and let me just approach the whole issue in this way. I'm just about to start my first in-person hearing in London in about 3 weeks' time. And that will be my first in-person hearing for 18 months. I think if anyone had said I won't be having an in-person hearing for 18 months and will just be facing a screen as I am today in March 2020, I wouldn't have believed them. But now it has become, I have to say, difficult to remember how to have an in-person hearing after all of this time. But let's just wind the clock back a little bit, because I remember in Singapore, in fact, recently, in 2019, I think it was, having an application to hear a witness by video link. Now, the courts were very reluctant to have anybody give their evidence by video link on the basis that traditionally everybody who has to be in a hearing has had to be in the hearing room. And still the rules exist in various jurisdictions which make it difficult for evidence to be given in court by video link. And therefore we started, I think, from a position where it was a rarity for somebody to give evidence from outside the court or hearing room in a court or arbitration. And so we've changed that whole attitude, and I think one can say that COVID has probably accelerated the way in which technology has developed, and indeed our thinking has developed by 10 to 15 years. I think it's very unlikely we would have had this step change in the way in which we deal with things without COVID. So there may be a silver lining coming out of COVID. Let's just look at what I mean by the reluctance of the courts in the past. They've always wanted to have the witness there so that you could see the witness shaking, their nervousness when they give an answer, and that was thought to be important. I think one can still see that on screen. It's obviously important that you organize the technology. We've found, for instance, that IT is important. One needs to have the infrastructure of IT. Although I have to say a lot of my cases I've dealt with on 4G rather than on a broadband network. In fact, one of the worst pieces of connection I had was a witness in New York. But what you do need is you need to have, as a judge or an arbitrator, you need to have 3 screens which you concentrate on: the witness, the evidence, transcript, and that is a tiring thing. So it is a more tiring way of working. You need to work out practicalities of witnesses who are remote. How do you administer the oath? What do you deal with when you've got interpretation? What about interference with witnesses who might be somewhere in a room where you don't know who else is in the room? Or what other links they might have to their WhatsApp, email, whatever else they have as social media. So you've got to have a different viewpoint, and protocols have developed which set out all of these matters, and now there are more or less standard protocols being used throughout the world which deal with the sort of matters which are necessary when you have a virtual hearing rather than a real hearing. Difficulties can sometimes arise in expert evidence. In most jurisdictions now, we have concurrent evidence, also called hot tubbing, between experts. And that's easy if you've got 2 of them there in front of you. If you've got 2 on different screens, it's a challenge. But one finds that because of being used now to looking at people on screen, that is becoming much less of a challenge. And indeed, in the case last week, there was absolutely no difficulty in having the 2 experts in entirely different jurisdictions on screen. The tribunal doesn't have that close connection. I can't look at my co-arbitrators and wink or draw breath in and give them that sort of talk. But we have WhatsApp. We communicate by WhatsApp or by some other social media when we're in the hearing to exchange views. We have breakout rooms. And so the whole technology has developed and we are now able to have a virtual hearing, which for all intents and purposes, I would have to say is as good as a real hearing. Now, what about the other feature of this? It's developed the ability for us to communicate worldwide at a time when global warming is causing concern without anybody having to move from their home locations. You have access to cases from anywhere. There are 1 or 2 difficulties of time zones, but it does avoid all the time and expense of travel and cuts down clearly carbon emissions. It also, I think, opens up possibilities, particularly in Africa, for regional centres to take a part. For instance, one of my cases recently, the regional centre was in Canada, but we were dealing with a case in Oman. And so you don't have to be at the regional centre. The regional centre can develop services which are used throughout the continent of Africa or worldwide in promoting services. So in short, I think we've learnt a lot in the past 18 months. I think it's developed our whole thinking, and I look forward to meeting both the challenges and the opportunities which it gives us over the next perhaps 15 years. Thank you.
Thanks very much, Vivian. That's an excellent introduction to the topic. I was particularly interested in a couple of points that you make that perhaps we can return to in the questions regarding the challenges you saw with some of the existing rules and whether they permit cross-examination, examination of witnesses by video link, and whether there's another piece of work which will need to be done in the future, which is to take some of these protocols and build them into some of the arbitration rules that we have. And the other point, which is something, of course, which we touched on in our introductory remarks, is this opportunity for possibilities being opened up for more disputes to be resolved outside the Londons, the Genevas, the Paris, the Singapore. Again, I think that's a topic which I'm sure a number of our participants will be very interested in some more views on that. We will come back to that, but now it's my pleasure to introduce my colleague in our Johannesburg office, Thethe Mokele, who is an attorney with us. Thethe specializes in the resolution of construction disputes. So she's very, very much on the front line, if I can put it that way, of briefing advocates and also taking instructions from clients. Thethe, you've obviously listened carefully to the points that Vivian has made from the perspective of a judge arbitrator, and that I think the high point was that to all intents and purposes, a virtual hearing was as good as a physical hearing, with of course some important qualifications. From your perspective as an attorney, though, as somebody who is briefing the advocates and importantly interfacing with the clients, I'd be interested in the lessons that you've learned over the last 18 months and whether you share some of the views that you've just heard around opportunities, and also somebody who is highly experienced in dispute resolution on the continent of Africa and who spends their working day on the continent of Africa. What views you have around opportunities that may be opened up for African disputes to be resolved on African soil. Thethe, I'll leave it to you to introduce the topic from your perspective.
Thanks, Richard, and good morning, everyone. I think, as Sir Vivian has mentioned, it's unlikely that we would be where we are today in terms of virtual hearings and proceedings had it not been for COVID. Certainly, I also haven't been in a physical courtroom or conducted any arbitration hearings physically over the past year. A lot of challenges have come up, which I will touch on briefly, not just in South Africa, but on the continent as a whole. But I think what I'll touch on as well is how these challenges that have been identified create opportunities for the African continent as a whole to position itself as a leading dispute resolution hub going forward in the resolution of disputes. And although it's been possible to conduct proceedings virtually in other jurisdictions, such as the UK, Singapore, etc., for some time prior to COVID, from a South African and definitely an African perspective, it was the pandemic that forced us, kicking and screaming literally, into the digital age overnight, as if preempting what was to come, and which was a great assistance to attorneys like myself on the ground, preparing cases and having to often do so remotely and away from our clients. The enactment of the Case Lines digital case and litigation system last year in the Gauteng, Johannesburg and Pretoria divisions was a great assistance that was enacted last year. Through case lines, files were opened and registered electronically, and the parties were able to register and invite all the other parties, including the registrar and judges, to have access to these matters electronically, which obviously facilitated virtual hearings where we weren't always able to be together, present physically in one courtroom. CaseLine has been a useful tool in facilitating virtual court proceedings during the pandemic. However, the system is still yet to be rolled out into other divisions, and once the rollout is complete, it will enhance uniformity in how virtual court hearings are conducted in all 9 provinces, which is obviously key for consistency. CaseLines has definitely made the administration of high court matters for attorneys and clients much easier and allowed for easier interface and exchange of documents, filing of pleadings, and access to documents in an electronic format. Outside of South Africa, other countries such as Kenya, Nigeria, and Uganda have also adopted virtual court proceedings in order to dispose of their pending and new cases in courts and arbitral institutions following on the pandemic. In addition to the adoption of virtual court proceedings, Ghana, Egypt, Rwanda, and Kenya have gazetted and implemented electronic case management systems, which are similar to CaseLines. However, due to the reactive manner in which most of these virtual courts were set up in most African countries, very few have comprehensive legislation, while the rest are operating without legislation, which is in itself a challenge. In order to bring the virtual court proceedings in line with the more advanced virtual hearings in alternative dispute resolution forums, such as arbitrations and adjudications, which are mostly privately funded and generally do not depend on the court resources or processes, a lot of investment, in my view, will be required in terms of resourcing capabilities such as access to internet, reliable power systems, and established efficient court processes to ensure that virtual court proceedings don't end up inhibiting access to justice, the very purpose for which they were intended to promote. This is because the majority of the demographic on the continent as a whole rely on the domestic and local courts to resolve their disputes, as they can't always afford the private resolution of their matters. The majority of citizens still struggle with access to basic services and resources, and the question that I've seen arise is whether this new norm is actually practical or even feasible. In addition to the investment required in infrastructure to ensure the effective conduct of virtual proceedings, educating communities will also be vital to ensure that there's an understanding of how virtual courts actually enhance parties' right to their day in court as opposed to inhibiting it, which has been a concern that has been raised by some clients, as well as not everyone has access to the technology required to sometimes dial in and participate in the proceedings. A further challenge is the fact that most court systems are already burdened with administrative backlogs, outdated infrastructure and systems, staffing shortages, and a general lack of resources. One wonders whether a move to virtual proceeding creates an additional burden to the courts, logistically and otherwise, or whether it will relieve some of that pressure. What is certain, though, is that one cannot set up an effective virtual process without an underlying efficient administrative court system. Even with all these challenges that we have identified locally and on the continent as a whole, though, it hasn't been all doom and gloom. And there can be no doubt that virtual proceedings have allowed parties their day in court and access to justice in a way that would not have been possible during lockdown, when people had restricted movements and could not readily travel to the courts and to the big cities as they would before the pandemic. Matters were run as they would in physical court, and parties who did not have access to the technology required were accommodated accordingly. So this shows us that this can be done, and virtual proceedings can be the way in which disputes are resolved going forward. In terms of private dispute resolution on the continent as a whole, virtual proceedings as an emerging trend is not expressly regulated, nor is there a uniform standard in terms of which proceedings are conducted. Further challenges which arise from this and have hindered development of virtual proceedings include privacy and data protection issues and available software to deal with this, a lack of technology resources amongst the population, and a mindset and culture issues. In some jurisdictions, there's been a huge resistance and pushback in terms of virtual proceedings, and there have even been constitutional challenges as to whether or not virtual proceedings are constitutional or whether they inhibit parties' right to access justice system fairly. All these challenges could definitely inhibit access to justice. However, with all of these challenges come the opportunity for growth and development. Various institutions have attempted to provide guidance on these issues through various resources that are readily available in a way that specifically caters to these challenges. Of particular interest is the Association of Young Arbitrators Protocol on Virtual Hearings in Africa, which was issued in April last year after the outbreak of the pandemic. And this protocol addresses specific challenges and circumstances that may arise in relation to virtual hearings in Africa. What makes the protocol more impactful is that it is drafted by Africa for Africa in a way which effectively addresses uniquely African virtual challenges to ensure that arbitration proceedings are conducted in a way that is in line with international standards and norms. Lastly, we've also seen a rise in the development of arbitration centers, which has greatly facilitated the conducting of virtual proceedings and the modification of arbitration rules of the various arbitral institutions, such as the Mauritius Chamber of Commerce and Industry Arbitration and Mediation Center, which offers virtual proceedings to parties where appropriate, the Nairobi Center for International Arbitrations, whose rules provided expressly for virtual hearings even before the pandemic, the Kigali International Arbitration Center, and the Arbitration Foundation of South Africa, to name a few, which facilitate virtual hearings. In closing to my introductory remarks, virtual courts definitely create opportunities for Africa in terms of dispute resolution. In the short term, all these gaps definitely present opportunities for innovation and development to create online systems that work efficiently and cater specifically to the unique challenges that we face. And if run effectively, they could even lead to them being adopted in other jurisdictions across the world. In the long term, the exposure that will be gained by arbitrators, attorneys, etc., once the systems are up and running and proceedings are being administered efficiently, will be significant in showcasing what we can offer as a continent, and that definitely the services that we can offer are up to par with other parts of the world.
Thethe, thank you very much. That was a excellent practical explanation of some of the opportunities and some of the challenges, and what needs to be done to make this work. I was very interested in your discussion around case lines and your point around how other parts of Africa have adopted something similar. There seems to be a continuing theme here, the developing theme around regulation, the need for comprehensive regulation. It does seem that there is a huge amount of reinventing of wheels going on around the world with various protocols, various regulations, and there may be something there around sharing knowledge and pooling knowledge and somebody capturing that. The other point, which I think we might pick up with Johan, is just this point around education. We've talked, I suppose, a bit about education of judges who have had to be educated around this. But that whole point about the culture, that there needs to be a cultural shift if we're going to move to these kinds of hearings is important. And that culture shift, I suspect, is linked a bit into trust. You know, the points Vivian was making about who else is in the room, what is that person getting on their WhatsApp? That's all to do with trust and culture and education. So there's a huge amount there. But your big point around opportunities, which is where you finished, I think is a very, very powerful message. Now, in terms of challenges, I'm very pleased to say that we have an actual real challenge here, because Johan, I think, has been struggling with the bandwidth and with the technology. If Johan is there, and he is, Johan, welcome from Cape Town. That doesn't really look very much like Cape Town behind you, but I think that's where you are at the moment. Johan, a welcome to you. Johan, everyone, is a member of the Cape Bar. He's a member of Keating Chambers as well, a dear friend of all of ours. He's done a huge amount for construction law in South Africa, being the co-founder and co-chair of the Society of Construction Law. His day job is as an advocate. His night job is sitting as a judge and arbitrator in South Africa, and obviously has a huge amount of experience of work, not just in South Africa but also around the continent. Johan, you've listened, I hope, technology permitting, to Vivian and to Thethe talking about some of the opportunities and some of the challenges and some of what needs to be done. This point about culture, which Thethe touched on, now, from my limited experience of working in Africa and in South Africa, one of the things which I think is admirable about the continent is the emphasis which is put on procedure and protocol and tradition. Do you see that as something which needs to change and is going to enable or inhibit the opportunities that you've heard touched upon as by Thethe and Vivian, and also just your experience as an advocate, how your taking of instructions, how your relationship with tribunals has been affected by what has happened over the last 18 months or 2 years. Johan, over to you.
Thanks, Richard. Morning, everyone. I'll start off by offering an observation from an advocate's perspective, which is that COVID in general and the introduction across the board of virtual hearings in particular have caused a mind shift in South Africa, at least, in respect of the manner in which arbitral proceedings are conducted. So Vivian touched on the tradition, very strong tradition of physical hearings, and in most African countries, so at some point under British rule, and this includes South Africa, and they incorporated English law of procedure into their court processes. As a consequence, there's a strong tradition established for over a century of conducting hearings in open court, and this tradition inculcated the view amongst advocates that a fair hearing is not possible unless a procedure akin to court procedures adopted and a physical hearing is had. And as a consequence, there's been a reluctance on the part of advocates in South Africa to adopt modern arbitral proceedings in their arbitrations, which include, for example, the exchange of witness statements, the conduct of limited duration hearings, application of the chess clock rule, and so on, all of which significantly reduce the time and cost of arbitral proceedings. So although arbitration referrals have been commonplace for commercial matters, in particular in construction in South Africa for a long time, arbitration was generally treated by advocates, I think, as a privatized court proceedings. And it was usual for advocates to advise their clients to agree that high court rules would govern the arbitration proceedings. Not unsurprising, given that we were trained from the outset in high court litigation, and conducting proceedings along high court rules meant that we could manage procedural risks using experience gained from decades of practice in that environment. But this approach was stifling South Africa's entry into the international arbitration arena. It failed to allow parties the advantages offered by arbitration. Third-party funding, for example. Third-party funders need to know what an arbitration is going to cost. You can't tell them what an arbitration is going to cost unless you have a limited duration hearing and specific procedures that have been commonplace in international arbitration for a long time, but which advocates were loath to adopt in South Africa. Traditional court procedure with no witness statements, unlimited duration hearings, leading witnesses orally in chief, written bundles, inefficient in the virtual environment. So when the first lockdown was imposed in March last year, there was at first a flurry of postponements of both court and arbitral hearings. Everyone thought that COVID was temporary, but eventually we realized that it was clear that adaptation was required if parties were to have access to justice at all. Virtual hearings, for which there was historic precedent in court rules, for example, taking of evidence on commission through virtual means, represented the closest alternative to a physical hearing. It represented the lesser of two evils. The court started adopting it, and it has become the norm in arbitration and other alternative dispute resolution processes in South Africa as well. But this represented a fundamental mind shift in terms of our expectation as advocates of what a fair hearing represents. And it required a complete rethink of how virtual proceedings should be conducted to ensure that parties have a fair hearing. In a sense, COVID has been a catalyst for a complete rethink of the approach that we take to arbitral hearings in general. Modern arbitral procedures easily adapt to a virtual environment. We have an exchange of opening statements in advance of the hearing. We have an exchange of witness statements in advance of the hearing, which allows us to present evidence in chief at the virtual hearing through the presentation of the statement. This reduces the time and cost of the hearing enormously. It allows for the preparation of electronic bundles in advance of the hearing, which are properly indexed and paginated and easy to access during the hearing. The hearing can now focus on cross-examination and re-examination, and the prior exchange of witness statements allows the tribunal to consider the evidence prior to it being presented, allowing the tribunal to clarify difficulties it has in real time with the witnesses in a much more efficient manner. These procedures, which have been the norm in international arbitrations for a long time, make particular sense in the virtual environment, and it's a short step from here to introduce limited duration hearings in the chess clock rule. Coupled to this is the experience gained that virtual hearings can be significantly less expensive than physical hearings. Traveling and subsistence costs are significant in most matters, and even more so in international arbitrations. It often runs to 25% of the cost of a hearing. The availability of witnesses are improved, and the cost of experts, particularly when coupled with limited duration hearings, are enormously reduced because the experts know when they will be needed and they only reserve the time required. Otherwise, they would have to reserve all of the time set down for an unlimited duration hearing, which could be weeks. Now the expert only has to reserve himself for a day or two. So presently, when I'm in discussion with my opposite number as to the conduct of an arbitration, I noticed that there's been a significant change in my opposite number's expectation of what a fair hearing in an arbitration should look like. There's a willingness to consider modern arbitral procedures, and the expectation that the hearing will be conducted remotely is universal. So 18 months later, it seems that the question is not whether a virtual hearing should be conducted, but rather whether there is sufficient justification for the incurral of all of the additional expense associated with a physical hearing, even if such a hearing could be safely conducted. I think as a second observation, it seems to me that there are opportunities for African advocates that are provided by the shift to virtual hearings. African practitioners haven't been traditionally engaged as party representatives in international arbitrations, even where one or more of the parties were African. Mainly, this is because the international arbitration centers dominated the arbitration landscape, and these institutions are situated in Europe. So it made sense to African parties to instruct legal representatives at the major centers where the arbitrations were going to be conducted, but this came at an enormous expense to African participants, not just in terms of traveling and subsistence costs, but also because the costs of European arbitration lawyers were orders of magnitude greater than the cost of African lawyers. So this geographical separation represented a major disadvantage in arbitration to African parties compared to their European counterparty, and was a barrier to entry into the arbitration process itself. It is not unusual, I've seen this often, for an African party to simply settle at best in order to avoid the cost of an international arbitration in one of the European centers, because it's prohibitively expensive for African businesses to conduct physical arbitrations in these global centers. And I guess this is why we have seen such a growth in regional arbitration centers in Africa, particularly in South Africa, such as AFSA, for example, because they offer to African parties a much more cost-effective environment, which makes the arbitration of smaller claims worthwhile. So what impact would the introduction of virtual proceedings have against this background? Well, it removes the cost of traveling and subsistence for parties, witnesses, and the tribunal. It removes the need to appoint legal representatives at one of the European centers and allows African parties to participate cost effectively in international arbitrations, even, for example, ICC arbitrations, by using local African legal representatives. And I think this supports the growth of arbitration practices within the African legal community, as it improves the business case. For example, for a Zambian party to instruct a Zambian advocate far removed geographically from the established arbitral centers to represent it in an international arbitration. And in doing so, it results in the transferal of arbitration knowledge to African practitioners and the ultimate development of African arbitrators, which I think is one of the main difficulties that African practitioners have. If you're not involved in arbitration, international arbitration practice, you don't pick up the skills that you need to sell your services in that environment.
Mm-hmm.
So I think the fact that we've gone virtual will removes geography from the equation and makes it possible for African legal representatives to become involved in international arbitration work.
Thank you, Johan. I'm going to stop it there if I may, because the questions are now starting to come in, and that point that you've raised around skill levels and opportunities is something which I think we're going to need to return to in the discussion. So if I might just start the dialogue now across the panelists. Perhaps, Vivian, before I forget, just ask a question that's been raised, which is something you touched on, and that's to do with time zones. Now, you know, I know that you work with a lot of international disputes from the UK, which could be in Australia or New Zealand. If one is working UK to South Africa, the time zone is virtually the same. UK to Mauritius, time zone is virtually the same. Ditto with many jurisdictions in Europe. If you're working east to west or west to east, then that's not the case. And the question that's posed is what happens when the time zones are not convenient? How then does one ensure fairness? Is it fair that a witness is cross-examined at 3 a.m. in the morning in their time zone, for example? How do you address those kinds of issues from the perspective of a tribunal to ensure fairness? Vivian, perhaps we could start with you on that one.
Time zones are certainly a major problem in international dispute resolution. I've recently had cases which go from the west coast of the USA through to New Zealand. What one finds is that one has to be flexible on sitting times. And therefore, you have to be flexible on the times where particular witnesses in particular jurisdictions appear in a hearing. So that, for instance, you might start a hearing at 6 o'clock in the morning in the UK so that you can deal with a witness in New Zealand.
Which is a linked point that's come in, Vivian. This question is whether a party could challenge a virtual hearing on the basis that they have not had a proper opportunity to present their case at a physical.
Well, that's a secondary point, but I think one has to remember that if people are in different time zones, they would be flying into different time zones, and we don't generally say that witness who has flown in with jet lag and is then cross-examined the next day has a ground for challenge, and therefore, when one looks at the international travel, one I think neutralizes that to a large extent with a virtual hearing and making sure the time zones work. In relation to challenges, to start with, as Johan said, we all said we'll delay the hearing. Then we realized delaying the hearing was no good. And so when we had virtual hearings, I had a number of challenges in my international arbitrations which said you can't have a virtual hearing. I have to say we rejected all of them, and I'm glad we did, because I think it has proved that you can have a virtual hearing which is as good as a physical hearing. There are, however, intricate arguments which arise, intricate arguments as to what is allowed under the rules of a particular arbitral institution or under particular court rules. There are also certain rules in certain countries about having witnesses in that country give evidence in a foreign court or in a foreign arbitration. And therefore there are a number of challenges which have been made. So far, I can say that the majority of those have been turned down, and there is at present a research project seeing to what extent the need for a physical hearing in order to have the normal natural justice rights is something which the world has legislated for, or whether in fact everyone is now accepting that physical and virtual hearings are the same.
That's a great point to finish the answer on, because that leads very well on to the second question I've got. And folks do fire the questions in. They're coming in on. I see them. They come up here on my Q&A. So if you've got questions that you want me to put to the panelists, do fire them through. If that's around opportunities in Africa, if it's around regulation, around any technical questions you have as to how these things work and what works, what doesn't work well, and now's your opportunity to ping them through to the panelists. Thethe, just picking up really with you on this point about fairness and that question which came in from our delegates as to can these proceedings be challenged. What has been your experience of clients' reaction to virtual hearing, that big shift which you've talked about and Johan talked about? What has generally been your experience? So a good experience, a negative experience? What are they saying works well? What are they finding doesn't work so well?
I think as a starting point, it's generally been more convenient for a lot of clients. Clients have been able to eliminate travel times to our offices, to court, etc., in order to participate in proceedings. And generally, they can participate from their offices, from their places of residence. So from that perspective, I think it's been quite convenient with the electronic sharing of documents and bundles. It's been much easier because clients have found that they actually prefer to do it online as opposed to sometimes coming in physically sitting for hours and hours going through the documents. They can now access them electronically, go through them for purposes of witness statements, etc. A concern about fairness, though, that has arisen is generally on when the other side is giving evidence. There's been a lot of pushback from some clients to say who is sitting with the witness from the opposing side in the room where they're giving evidence. Are the attorneys interfering? Are they passing them notes? What's going on? Where are they? So we actually had a hearing last year that was postponed on that basis because the parties just couldn't agree on this issue of how witness evidence was going to be given. So I think that's definitely an area where it's been a bit of a sore point, but I think that arises more just from mistrust between the parties as opposed to really going to the root of whether or not the proceedings are fair, okay, which I think they have been.
Okay, Thethe, thank you very much. Johan, from an advocate's perspective, now, again, I mean, you talked very, very, very eloquently around this point about the benefits traditionally seen of a physical hearing, modeling, you know, what has worked so very well in other parts of the world over centuries, frankly. Do you see that as now changing? The question I have is are virtual hearings here to stay? Are they going to become the new normal, or are we going to now find that we're going to go back to those hearings which were postponed in the early days? I've got your point in mind here, which the point you made. The question is, is not whether there should be a virtual hearing, but whether there is sufficient justification for a physical hearing. Are you of the view now that this is what we're going to see going forward?
I think so. My experience of virtual hearings has been, yes, there have been challenges, there have been difficulties in some hearings, but generally speaking, if you do it properly, there's a lot of preloading of work that you don't normally have with a physical hearing, and it makes a virtual hearing work really well. It's cheap, it's effective, it works well. Really, I think you really have to make a case now, in my view, to have a physical hearing. I mean, why would you incur the additional 25% of cost? Why would you want to do that? Because you really can have a very, very efficient hearing with a virtual hearing, better so than, I think, in some respects, than a physical hearing.
Okay, thank you. And Vivian, Johan touched on the need to upskill, if I can put it, the experience of regional arbitrators, regional advocates, regional judges, so that they are better able to resolve disputes outside of the traditional regional centres. Do you have any thoughts as to how that might happen? I mean, I remember that you worked for a while with the Dispute Resolution Centre in Mauritius. A linked point to that is whilst I as a client can go to anywhere in Africa and get my dispute resolved now by a local advocate, if I don't have to have that attorney fly in from New York, why don't I just get that person to do my dispute virtually, but from New York? So are we actually going to see these opportunities emerge regionally? The 2 points are linked because the skill sets need to be there, because it's only if they're there that the clients will have the confidence. So 2 issues. How do you see skills being developed? And if they are developed in that way, do you see these opportunities emerge, or do you think that the traditional centres are fundamentally just too strong and it's always going to be that way?
Well, it's interesting because, of course, all of us started out with our first arbitration without any experience. And that is, I think, an important starting point for looking at this issue. What I was interested in, Thethe and Johan's points, is really the amount of upskilling of the procedures which has come with the virtual development. In other words, you can't have such cumbersome systems in place. And I think courts around the world have found that they've had to move to e-filing and other techniques in order to modernize the courts. And I have to say, modernizing the courts, modernizing arbitration is the first step in upskilling the lawyers, the people who are going to have the skills. And once they've got the skills, then the competition with an advocate coming in from New York or from London or from Singapore or elsewhere in the world starts to look not so much of an advantage. And so it's important to have the local upskilling. Interestingly, within Africa, I'm dealing with upskilling of engineers at present. And that is a similar challenge, which is to produce the processes which allow everybody to upskill. And I think one of the particular opportunities of the virtual world is that opportunity to modernize and to put in place the skill sets which are needed to bring everybody onto a par.
And Thethe, just going to you now, this point that you raised about the lack of trust between parties, and how I think you said you had to have a hearing, which just never took place last year because the party just couldn't agree. Questions come in: is a way around that for the participant, the person who's going to give evidence, to actually swear an affidavit to the effect that they are alone, they will be alone in the room. This is probably perhaps one for both, well, for all of you, really. Thethe, what would that have solved your problem?
I suppose it could have, but what we ended up doing is that when evidence was being taken, our counsel actually asked the witness to make those declarations, and it was actually proposed that their camera should be positioned in such a way that we have a better view of the room and to see who is sitting around the witness. So yeah, very posed questions were asked. Are you alone? Who was with you? Do you confirm that this is the truth, etc.? So an affidavit is one way, but it was done orally in the end, which seemed to achieve the purpose.
Yeah. Vivian and Johan, would you have a preference as to how you deal with this? It's a very important point because if clients don't have faith in these proceedings, they're not going to happen. So this question which has come in is a very, very, very good question.
Well, I think that 3 points, if I could just make them. The first is, I've had a lot of cases where the parties have said if there's a witness somewhere, the opposing party wants somebody from that law firm to be present with them. That was imposed for the first witness, but then it wasn't imposed for any of the other witnesses because it was just seen to be hopeless. The second thing is, part of the protocol is to have an oath which makes sure that the person isn't interfered with. For instance, they have to show them switching off their phone. They have a camera which they revolve around the room and they sit with their back to the door. There are practical ways of doing it. And to be quite honest, in this technological age, I wouldn't think it's beyond the skills of people to bug hearing rooms, to do all sorts of other things to throw it. And I think there's a suspicion, but in my experience, it's more virtual than a real concern.
Johan, would you agree with that?
Yeah, I do. I think, you know, if you have a dishonest witness, getting a declaration from him that he's alone in the room isn't really very valuable. But as Sir Vivian says, there are very easy technological fixes to this problem. You know, you can just make sure that the camera angle is such that you can see exactly what he has in front of him, and you can see that nobody else is in the room with him. So I think those are problems which are easily solved from a technological perspective. There are concerns though. You have people that have concerns with it.
Okay. We are, I'm afraid, coming rapidly to the end of this fascinating webinar. I'm going to return to our panelists briefly though, just for any really very brief closing remarks that they may have. The questions that we've had have been great questions, so we've run on a bit, but I hope that's all right. I'm looking at the participant list, and we haven't had people drop off the chat, which is my cue that it's time to close. But perhaps just some any closing thoughts, perhaps with you, Vivian, first.
Well, I think the main closing thought is to use the opportunities which have come from the virtual world. As I've indicated, I think it allows us to improve a lot of the processes of litigation and arbitration. And I think in particular, what it does is to show that technology can be a facilitator for a much better world in which we don't have all the inefficiencies that we've had in the past with physical hearings.
Thank you. Thethe?
For me personally, I think virtual hearings are the future. I think they're here to stay. I think from an African perspective, we definitely still have a lot of challenges in terms of infrastructure and upskilling. But again, that is not something that is insurmountable. And with the correct investment, I think definitely we can facilitate better virtual hearings going forward.
Thank you very much. And Johan, last but by no means least.
Yeah, I think for all of the bad that we've had from COVID, it has acted as a catalyst for completely modernizing South African arbitration practice. And I think that is something which would otherwise have taken 5 to 10 years to do. And it's done that in 18 months.
Thank you very much. And thank you to all of you for the questions, and to our panelists for a fascinating conversation. I hope everybody's enjoyed it and found it of value. It's lovely to be ending this webinar on a very, very positive note. It's been a very, very grueling and tough couple of years. Hopefully we're now coming through it, and it's nice to be ending our webinar with a positive note about opportunities and not just about challenges. Our next session is on the 20th of October, and we hope that many of you will be able to join us then. We will be continuing our theme of discussions in relation to dispute resolution, speaking around mediation and adjudication through the virtual lens. That will be chaired by Abdul Janadu from Keating Chambers, and he will be supported on the panel by David Vilgemode from the Cape Bar in South Africa, also a member of Keating Chambers, and my colleague Mohammed Somre from our office in Johannesburg. But on behalf of us at Pinsent Masons and Keating Chambers, we wish you all well. Have a good day, everybody. Stay safe, and hopefully see you again on the 20th of October. Recording of this event will be circulated on Friday. Thank you very much. Bye-bye.
Thank you.